Now, today, we will be talking about Astrida Benita and Hermanos Carrizosa versus the Republic of Colombia, eh, by my colleagues Nelson Duarte, John Malagón, and who is speaking, Martin Venegas. What we have to understand about this case is that this case was about a liquidity proceedings and cessation of payments. There were two claims that arose, which was the one of Astrida Benita versus Colombia and Hermanos Carrizosa versus Colombia. The dispute of Astrida Benita Carrizosa against the Republic of Colombia arose due to some measures adopted in 1998 by the government of Andrés Pastrana when they decided to intervene in Banco Gran Ahorrar by the arbitral tribunal that was created on December 11 of 2018 before the International Center of Settlement of Disputes. So what happens in this case? There was a first decision that was issued in 2005 by the Administrative Court in favor of the Colombian state. Later on, this decision was appealed, and in 2007, the Council of State ruled in favor of the investor, in this case of Astrida Benita. 2 years later, in 2009, there was another request from the Colombian state for a review to the Constitutional Court. 2 years later from that request, in 2011, the Constitutional Court reversed the decision that the Council of State gave to the investor, Astrida Benita. And the arguments from the Constitutional Court to reverse this decision was that it was due to substantive and procedural and factual errors. And well, lastly, in this case, one perfect example of how we can see some legal instruments being applied here is the agreement between the Republic of Colombia and the Swiss Confederation. This was an agreement between both to the promotion and reciprocal protection of investments. What they were intending was to create or maintain favorable conditions for investments by investors. Uh, well, in this case, the example is the case of Estrella Benavita, and recognizing the need to promote and protect foreign investments with the aim to foster the economic prosperity of both states.
Okay, doing the analysis of the case, the tribunal decide and solve the dispute of Astrida Benita Carrizosa against the Republic of Colombia through the ruling of April 19 of 2021 by solving the following legal problems. Okay, the first legal problem that solves the tribunal is, can an investor submit to arbitration a dispute based on events that occur before the entry into force of the investment treaty under which it seeks protection? And the answer that the tribunal gave to this question was negative, referring to the international custom of the non retroactivity of treaties by the Article 28 of the Vienna Convention of the Law of the Treaties, and also the Article 10.1.3 of the treaty in question. It considered that it is undisputed that the actions or omissions of the contracting state prior to the entry into force of the investment treaty and will not be analyzed under the rules of the treaty. Likewise, it recalled that under the international rules of state responsibility, the act of a state does not constitute a breach of an international obligation unless it is bound by at the time of its occurrence. Okay, responding to the second legal problem that uh, solved this ruling, who is the question is declaring jurisdiction over a claim filed under a treaty in respect of facts prior to its entry into force, an exemption of the principle of non-retroactivity. And well, the answer that the tribunal gave to this question in this specific case that is that it was evidence that the decision of the Constitutional Court could not be studied separately from the actions prior to the treaty, since it did not revive the measures of the study of their legality. In reaching this conclusion, the court took into account that the request for nulli before the court is limited to the study of the circumstances in which due process has been seriously affected and does not include a review of the merits of the case. Finally, it concluded that the fact that the constitutional order had not annulled or correct the acts of a state does not imply that these can be understood under the treaty. Okay, and finally, the third legal problem that the tribunal solved in this ruling is, can the most favored nation clause be used to change the conditions on consent to arbitrate? And the answer that the tribunal gave to this question was negative, because according to the Article 12 of the treaty, the consent to arbitrate given by the states is limited to disputes over expropriation and compensation, transfers, denial of benefits, and special formalities and information requirements. Therefore, it is not covered by the most favored nation clause, dismissing the plaintiff's claims.
Okay, we have three conclusions. The first one, it is if I could use the BIT that comes in the future to defend my own cause based on facts that comes in the past. What does this mean? The case of Renoir and Carrizosa occurs at the end of the 20th century, and the BIT with the United States enters to the Colombian system in 2012. What does this mean? They could use that BIT that comes in this century for situations of the last century of the past. The answer was no. We could not use that BIT as an argument, but we could use them only for situations that come forwards. For example, the judgment of the Constitutional Court of 2014. Okay, the second conclusions go in order of the time. The tribunal said that basically they could not know about cases that started in the past. What the claimants consider is that they could know about the 2014 decision of the court, but they say no. This decision is attached, have the origin in the past in 2011, when the BIT don't have any validity in that moment. What does this mean? They could not know about facts of the past. This go in order with the first conclusion that we have, but in the substance of the case. The final conclusion goes in order that they could not use an arbitrator that don't have the competence to know about a specific topic about the financial services. This includes the thing about the most favored nation. Despite of their existence clause, they have the application of the most favored nation. They could not use them. They could not use, for the present case, the BITs of Colombia with Switzerland and India in relation to the BIT with United States because Colombia never give that permission, they never give that competence to the arbitration court to know about this type of things. That was the reason why the most favored nation clause don't apply in the present case.